Hi and welcome to this latest immigration law update video. This is the fourth in my series of videos looking at the Upper Tribunal reported decisions for 2020. So in this video, we're going to look at the reported decisions for April 2020. And in fact, on Bailey, there are only two of them. One looking at extended family members and the question of dependency, and one looking at the definition of what is a foreign criminal and overseas convictions. So let's have a look at them. The first case is Chowdhury, extended family members, dependency. And this considers the words in the EEA regulations in Regulation 82C of, in fact, the 2006 regulations, although the provision is similar in the 2016 regulations, that somebody continues to be dependent. So this concerned an individual who entered the United Kingdom in 2011. He had entry clearance as a student, but that was subsequently cancelled and he absconded. In 2016, he made an application under the EEA regulations as the dependent extended family member of his great uncle. Now, that was refused and it came before the first tier tribunal. And the first tier tribunal judge accepted that before he entered the United Kingdom, he was in fact a member of his great uncle's household, and in fact he was dependent on him. But the judge went on to find that there was a period prior to the application being made, in fact between 2011 and 2014, where he wasn't in fact dependent and he was self-sufficient during that time. So that was challenged to the Upper Tribunal on the basis that there was no requirement for continuous dependency under Article 3 of the directive. Permission was refused by the first tier and Upper Tribunal, but in fact there was a CART JR where permission was granted, and there was an indication that the tribunal should give guidance on this issue. So the Upper Tribunal look at the directive, Article 3.2, and the duty to facilitate entry and residence of extended family members, which obviously different to close family members. They look at the case of Rahman and they look at recital 6 of the directive. And the Upper Tribunal find that the words continues to be dependent. Now, in terms of extended family members, the member states are empowered to legislate on dependency through national legislation. And they find that actually continues is not just past dependency and present dependency, but there needs to be that unbroken period of dependency. So on the basis of the judge's finding that there was this gap between 2011 and 2014, they dismissed the appeal and found that he didn't continue to be dependent. The second case is about foreign criminals, and particularly about a foreign criminal whose only convictions are outside the United Kingdom. In paragraph A398 of the immigration rules, it refers to foreign criminals, but doesn't really define it, whereas section 117D2B of the 2002 Act says that it's somebody who's convicted of an offence in the United Kingdom. Now, there were these conflicting authorities, the case of Andell, where Judge Coker had found that actually the immigration rules were wider and didn't just cover those convicted of offences in the United Kingdom, but could cover those convicted abroad. The case of OLO, Upper Tribunal Judge Kopacek took a different path and found, because of the definition in section 117D, the immigration rules should be interpreted consistent with that, and the rules only apply in terms of foreign criminals to those convicted in the United Kingdom. In this case, the Upper Tribunal follow the case of OLO and find the case of Andell should not be followed. So a foreign national who's been convicted outside the United Kingdom of an offence is not, by reason of that conviction, a foreign criminal for the purposes of rules A398 to 399D of the immigration rules. This, in fact, was a case that concerned an Albanian national. He'd entered the United Kingdom in 1997 following a murder conviction in Albania. He was subsequently convicted in absentia in Albania of armed robbery, although that was set aside ultimately by the Albanian Supreme Court. There had been a number of false asylum claims, there had been extradition proceedings. Eventually, in 2015, he applied in his own identity for ILR, and the Secretary of State made a deportation order in 2017. There was an appeal on protection and human rights grounds. The upper tribunal, the appeal was dismissed. The upper tribunal set aside the decision in terms of Article 8, not in terms of the protection claim. And in redeciding the Article 8 claim, leading counsel raised the issue of the safety of the conviction in Albania. So that was looked at, and expert evidence was submitted. In fact, the procedural point raised at point 3 of the head note was about a late expert report that the tribunal refused to admit. Now, actually, the case then wasn't completed in the time allocated and went part heard. So there was an application while waiting for the reconvened hearing to admit this evidence that they previously refused to admit. And the tribunal say, well, in the absence of a material change in circumstances or a circumstance where the tribunal has been misled, it's a very rare case in view of finality of procedures that we should revisit or vary an interlocutory order. So they refused, even though the case had gone part heard, to allow to introduce that expert report that they previously refused to admit. So ultimately, even though the foreign criminal provisions didn't apply to this appellant, a proportionality assessment was made, and reference was made actually to the entry clearance suitability requirements, SEC 1.4, where somebody can be excluded from the United Kingdom because of convictions. And that's obviously subject to Gen 3.22 unless there's unjustifiably harsh consequences. So in the light of that, the upper tribunal undertook a balancing exercise and found the public interest outweighed the appellant's family and private life, particularly in the light of his murder conviction. But the takeaway point ultimately is somebody who's convicted only of an offence outside the United Kingdom is not a foreign criminal, and the rules and 117 do not apply in those circumstances. Those are the two cases for April 2020. So I'll be back in the next video. Hopefully there'll be some more from me. I hope that's helpful.